understatement, wouldn't it?
Absolutely. I hold Jordan to all accountability for the accident. I think it's a shame that he was zoo manager at the time.
To clarify for the court, you hate the party that you're testifying against today.
I think that Jordan had full responsibility for the child's death. So yes, I would say that I hate Jordan Hastings. He was a horrible manager and he was not a responsible person in general.
All right, but talking about Jordan Hastings' manager job, I understand that on the afternoon of November 19th, he had a safety meeting.
Yeah, the safety meeting lasted way too long. It was really weird because Jordan had never emphasized safety once before, so it was pretty out of character.
But at this meeting, because safety was top priority, he went through the protocol line by line.
Yeah, it was pretty clear that no one wanted to pay attention because he was literally reading from the handbook line by line. I don't see how it could have helped any of us.
But nobody was allowed to leave until everyone understood the protocol. Is that correct?
Your Honor. Under Hope v. Grant, the opposing counsel is not allowed to use a prior good practice to establish a certain character trait of the Robinson Zoo.
Counsel, do you have a response?
Yes, Your Honor. Hope v. Grant actually establishes that we are allowed to bolster the defendant's character during the plaintiff's case in chief due to Continental's prohibition against calling rebuttal witnesses.
Your Honor, may I respond?
Yes.
My apologies, Your Honor. That was Hill v. Cleveland, not Hope v. Grant.
Okay.
Counsel.
So that response was to Hill v. Cleveland. Under Hope v. Grant, the defense is not allowed to use certain acts to bolster the defense or Robinson Zoo's liability or lack thereof, seeing as this is exactly what the party opponent is attempting to do with this line of questioning. It should not be continued today.
Counsel, do you have a brief response?
Yes, Your Honor. And once again, pursuant to Hill v. Cleveland, we are allowed to bolster the defendant's character during the plaintiff's case in chief under Hill v. Cleveland.
I tend to agree. I'm going to overrule the objection.
Ms. Jordan Hastings went through the protocol line by line.
Yeah, he did. It was really strange because he had never done anything regarding safety or training in any aspect before.
Nobody was allowed to leave this meeting until everyone understood the protocol.
Yeah, but I don't think any of us left with any greater understanding of the protocol. I mean, it was hard to pay attention when it was so boring because it was line by line of the safety handout.
Ms. Fields, you just said it was hard to pay attention, but in your affidavit, you say that you were paying attention during this meeting, don't you?
Oh, sure I was, but you can imagine it was hard to since, you know, it was line by line of the safety handout, which I had never seen before because I didn't receive any training while I was on the job.
Now, I want to talk about the day in question. When McConnell High students arrived to the zoo, their teacher, Mr. Carpenter, was explaining the importance of following the rules, wasn't he?
Yeah, I think he said something about his own personal rules about no phones, and then he said to follow the rules, yeah.
He also said that students needed to respect the zoo rules.
He said that they were required to follow the rules beforehand, as most teachers do.
But while he was explaining these rules they needed to follow, Tommy Thompson and Lee Stevens were talking.
Yeah, I overheard them talking about something. I overhear a lot of what the students talk about, and I never really know what they're discussing.
Tommy asked Lee, you understand how you're supposed to film a click-clack, right?
Yeah, something along those lines. Again, I had no idea what they were talking about.
And he even said it would be the craziest click-clack yet.
Objection, Your Honor. This is hearsay, seeing as it's trying to go to the truth of the matter under previously established Crenshaw v. Roth.
Your Honor, this is an admission by a party opponent, as it is Tommy Thompson. In the case today is Tommy Thompson versus Robinson Zoo.
Your Honor, may I respond?
You may.
Seeing as my witness is a plaintiff witness, my witness is not allowed to testify to another plaintiff witness's discussion, seeing as Lee Stevens is a witness present here today in court, as well as the fact that my witness is representing Tommy Thompson's estate. This is still not a party opponent, seeing as my witness is not allowed to testify to another witness's admissions of the same party.
Your Honor, if I may very briefly.
Yes.
Testimony was within my own question. As I asked, Tommy Thompson even said it would be the craziest click-clack yet. Tommy Thompson is my party opponent in today's case, making the testimony that I said an admission by a party opponent.
I agree, counsel. I'm going to overrule the objection.
So he even said it would be the craziest click-clack yet.
Yeah, something along those lines. Again, I never have any idea what the students are actually talking about.
But once on the baboon observation deck, Lee Stevens asked, are you going to do it?
Yeah, I think he said something along those lines. I was overhearing a lot of what the students were saying, so I have no idea what they're talking about.
You thought that what they were talking about sounded like trouble, didn't you?
Something like that.
And you reminded them of the rules.
Yeah, I made up some rules. I told them some rules and I, really shouldn't have because I didn't know any of them myself.
But in your affidavit, you did say that you reminded them of the rules.
Oh, sure. But seeing as I had received no training, I don't know if it was really a good, way for me to give it to them.
And just to clarify for the court, Tommy responded to Lee's question, "Are you going to do it?" by glancing around, nodding, and asking if anyone was watching.
Yeah, I was paying attention during that part. I think that's around what he did.
No further questions, Your Honor.
Thank you, counsel. Will there be a redirect of this witness?
No, Your Honor.
Witness, you may step down. Please call your next witness. You have 13 minutes and 3 seconds remaining for direct.
Your Honor, the plaintiff calls Harper Reynolds to the stand. May I proceed?
You may.
Good morning, Ms. Reynolds. Please state your name and occupation for the record.
My name is Harper Reynolds, and I'm an independent contractor.
And where did you go to school?
I earned a bachelor's degree in structural engineering from the University of Continental.
So what did you do after school?
Well, I started at the very bottom of TMW engineering and worked my way to the top. 2 years later, I was lead structural engineer, youngest employee ever to do it too.
So what did your job as the lead structural engineer entail?
Oh, I worked with a lot of commercial construction projects, not to toot my own horn, but I was pretty decent at my job.
So what did you do after working at TMW?
I left TMW after 5 years and started my very own business, Harper Reynolds LLP.
And what would you say is your business's primary job?
My life and business revolve around consulting and inspecting various structures. I work with a lot of luxury architecture in Continental. It's my passion.
Thank you. And what is your relationship with the Robinson Zoo?
The Continental Zoo Association contacted me and asked me to inspect the Robinson Zoo in November of 2019. They wanted to ensure that all of the exhibits were structurally sound, but I'd never worked with the zoo prior to this inspection.
And Ms. Reynolds, how does your commercial project background relate to your understanding of zoo structures?
To build an apartment or a hotel, you have to have a thorough understanding of basic structures like fences. The first lesson you learn in engineering school is the importance of a solid structure. So working with all these buildings has really taught me what instability looks like, no matter the material.
Thank you. At this time, the plaintiff moves to enter in Ms. Harper Reynolds as an expert witness in structural engineering.
Are there any objections?
No objections, Your Honor.
She is so entered.
So when was the last time you visited the zoo?
I inspected the zoo on November 12th, 2019.
And what condition was the zoo in when you last inspected it?
It wasn't what it used to be. A lot of the zoo's exhibits were closed and even more.
Objection, Your Honor. Improper character evidence pursuant to Hope v. Grant.
May I respond, Your Honor?
You may.
Pursuant to Hill v. Cleveland, this is admissible, seeing as the plaintiff is allowed to testify to the zoo's conditions, so therefore it is not improper character evidence.
Your Honor, may I be heard?
You may.
While opposing counsel has cited a case law, they have not cited any exception to their argument. Additionally, Hope v. Grant outlines that any prior bad practices, such as the closing down or fixing of these enclosures, is not allowed to prove that the Robinson Zoo was negligent at the time of the baboon exhibit or Tommy Thompson's death.
May I respond, Your Honor?
Very briefly.
Pursuant to Hope v. Grant, this is admissible, seeing as one, it is Ms. Reynolds' opinion pursuant to Rule 405A, and second, it is still admissible under Hill v. Cleveland, seeing as the plaintiff is allowed to testify to the zoo's conducts because they are the party opponent.
I tend to agree, counsel. I'm going to overrule the objection.
Yes, Your Honor.
Thank you.
Would you like me to repeat the question?
I think I got it. A lot of the zoo's exhibits were closed and even more of it was in shambles. It just wasn't what it used to be.
And what did you inspect on this day?
I inspected the entirety of the zoo meticulously, but the fence at the baboon exhibit was particularly disturbing to me.
So would you recognize a diagram of this fence as shown today?
Yes, I would.
Your Honor, will the bailiff please screen share what has been previously marked as Exhibit 4, which has been pre-entered into evidence pursuant to Stipulation 9? And may I hand my witness a clean copy?
You may.
Showing opposing counsel, clean copies. Ms. Reynolds, what is this document?
This is a copy of the diagram of the observation deck and fence at the baboon exhibit at the Robinson Zoo.
And how does the fence's structure ensure its stability?
Truthfully, it doesn't. It's a wooden fence. Even though it's pretty, wood doesn't last long and usually falls apart in about 15 years. Because wood rots so quickly, it's not the best material to protect people from danger, and especially to protect them from wild animals. Safety, not aesthetic, should be the priority in engineering.
So in your opinion, what material is more sustainable than wood?
Metal fences last much longer. Chain link fences, for example, constructed of steel wire, usually last 40 or 50 years and cost substantially less than a wooden fence. Metal does not crumble easily. Trees, on the other hand, are prone to falling.
Thank you. So looking at page 1 of this exhibit, can you show the jury what you observed about this observation deck?
Of course. The observation deck is below the main level and it allows visitors to get closer to Junior and the other baboons. I thought it was strange the zoo would allow people near such an aggressive animal. Like I said, in construction, safety must always be the...
Objection, Your Honor. Your Honor, the testimony regarding the zoo allowing guests near the junior baboon is irrelevant due to the bifurcation rule according to pretrial order 2.
Your Honor, may I respond?
You may respond.
Pursuant to case law Wagner versus ABC Toys, the Robinson Zoo has a responsibility to warn guests of all dangers, and seeing that, one, this has nothing to do with the bifurcation since it's specifically about the fence, which is called in question today, and two, the Robinson Zoo owes a safe environment to all of their guests. This is admissible and doesn't have to do with the damages, but it does have to relate to the liability.
Your Honor, may I be heard?
Yes.
The issue here is the fence, not the exhibit which the fence is at, but the structure of the fence itself. By bringing in testimony of Ms. Reynolds' opinion concerning the zoo's treatment of the customers in regard to the baboon junior, this is irrelevant because it doesn't go to show the safety of the fence and how it affected Tommy Thompson on the day of the incident, but rather is a improper opinion and is irrelevant in today's case.
I tend to agree, counsel.
Are we frozen or are they frozen?
Hello, are you there, Your Honor?
Can y'all hear me?
Yes, now we can.
Sorry, I just froze for a second. I'm gonna sustain the objection. Please continue.
Yes, Your Honor.
Sorry for that delay.
So moving to the second page of the exhibit, what condition was this fence in when you inspected it?
Well, the protective stain was completely washed off, so I could see every fault. The wood was splintering and the posts were wobbly. One post was particularly wobbly, so much so that it could have easily come out of the groove, especially because the posts were barely secured in the ground when they were first installed.
So what were to happen if someone leaned against this fence?
Given enough force, the post would come out and the beam would fall. That's on either side of the fence. It is not secure enough to withstand almost any amount of pressure.
Thank you, Ms. Reynolds. And what did you tell Jordan Hastings after your initial inspection?
Well, originally I told Hastings that I thought warning signs might suffice, but that I would...
Your Honor, hearsay pursuant to Crenshaw v. Roth.
May I respond, Your Honor?
You may.
It's admissible under Rule 803(1), seeing that this is a present sense impression because Ms. Reynolds, the declarant, is describing a condition of the fence while she was perceiving it, and therefore it is admissible and does not fall under Crenshaw v. Roth.
Your Honor, may I be heard?
You may.
Crenshaw v. Roth outlines that hearsay testimony is hearsay even to the declarant who is giving it in court. Additionally, opposing counsel has cited present sense impression. However, this assessment of Ms. Reynolds of the fence when she went to go talk to Mr. Hastings was after her initial inspection, not as she was perceiving it. Therefore, it doesn't qualify as present sense impression because it was after she had inspected the fence initially.
Your Honor, may I respond?
No, counsel, I agree with the defense. I'm going to sustain the objection.
Yes, Your Honor.
So what made you choose, after a more thorough inspection, what did you conclude in your final report?
Well, in my line of work, double checking is crucial to ensure accuracy. So I took the original plans and went back to the exhibit to finalize my investigation. You know how the old saying goes, measure twice, cut once, it's like that. So I looked at the observation deck plans, and saw that it was 25 feet above the ground, which is a fall that could fatally injure someone. This height, coupled with the poor construction, makes the fence incredibly dangerous to anyone who leans against it.
Thank you. And how did Jordan react to your change in instructions?
Well, when I told Hastings about the problems with the fence, they looked at me like I was crazy and spoke in a defensive and arrogant way. Even after...
Objection, Your Honor. Speculation.
May I ask the opposing counsel to clarify as to why this is speculation?
Your Honor, may I be heard?
Yes.
Ms. Reynolds has just testified the mindset of Mr. Hastings, saying that he was looking at her a certain way. And to give this testimony, she is delving directly into his mindset, talking about what he was thinking in that moment and what he was feeling. Therefore, this is speculation.
May I respond, Your Honor?
You may.
Under Federal Rules of Evidence 701, my witness is testifying to the rational perception, and she's not testifying to Jordan Hastings' mindset. Rather, her exact statement was that he spoke to me in a defensive and arrogant way, and that is just how she rationally perceived it, not testifying to his actual mindset or thoughts at the moment.
Your Honor,
I tend to agree. I'm sorry, counsel. I tend to agree. I'm going to overrule the objection. Thank you.
So, would you like to finish your response?
Yes, please. Jordan Hastings spoke to me in a defensive and arrogant way, even after I explained that pushing on the beam with enough pressure could force it out of the post.
And what instructions did you give Jordan Hastings to ensure the safety of the fence?
In my report and verbally, I instructed Hastings to either fix the fence entirely or get a second inspection.
Objection, Your Honor. This is hearsay pursuant to Crenshaw v. Roth.
Your Honor, may I respond?
You may.
The Federal Rules of Evidence under Rule 803(1) specifically states that my witness is allowed to testify to her present sense of impression while she was perceiving it or thereafter, and this is thereafter, so therefore it is admissible and she is allowed to testify to it. And I'd say that this is really relevant, seeing as her report is crucial to determining the facts of today's case. We need to hear what the report actually said.
Your Honor, may I be heard?
You may.
Your Honor, while my objection was not to relevance, this falls under Crenshaw v. Roth because Crenshaw v. Roth outlines that the witness who is giving a statement, the declarant on stand, their statements also qualify as hearsay. Now, opposing counsel has cited present sense impression. However, they have not given a window as to when Ms. Reynolds gave Mr. Jordan these instructions. They're saying that it is immediately thereafter. However, this was after she conducted not one, but 2 long inspections. Therefore, this does not fall under the exception of present sense impression, as opposing counsel has outlined.
May I respond, Your Honor?
Briefly.
This does fall under present sense impression, seeing as she told the Jordan Hastings her perception immediately thereafter her inspection, which still falls within the time frame of present sense impression, is therefore admissible.
I tend to agree with the defense. I'm going to sustain the objection.
Okay,
Yes, Your Honor.
so moving on, after the incidents happened, how, in your opinion, did the fence play a role in it?
Well, when I heard on the news about the death of Tommy Thompson, I knew that the fence had played a role. So I called the Continental Zoo Association and recommended that the Robinson Zoo lose their safety accreditation. The fact is that I told Hastings to close the observation deck and they didn't, which is why I'm in court today.
Thank you, Your Honor. No further questions. The defense reserves the remainder of our time for other plaintiffs, sorry.
Thank you, counsel. Will there be a cross to this witness?
Yes, Your Honor, there will. Before I proceed, Your Honor, can you and Ms. Reynolds see and hear me clearly?
Yes. You have 8 minutes and 26 seconds for your cross.
Yes, Your Honor. May I proceed?
Yes.
Hello, Ms. Reynolds.
Hi.
Now, you consider zoos to be beneath you, correct?
Well, the structures that I normally work with, luxury goods and 5-star hotels, the complexities in those structures are just incredibly advanced and a little bit more interesting. What I meant by beneath me is just that the structures of the zoo are not as interesting as the 5-star hotels that I'm used to working with.
Right, I understand. And these 5-star hotels and new apartment buildings that you work with typically contain steel structures as part of their frames, correct?
There's steel, there's wood, there's so many different materials. They're very complex. They work together in incredibly interesting ways. It's really fascinating.
But that suggests to my question that the buildings you typically work with contain steel structures?
As well as many other materials, yes.
All right. Now, around the time you took this job at the Robinson Zoo, you said that business was slow for you, correct?
Small business, there are ups and downs in it, as all things are. So it was a little slow in that I was able to squeeze them into my schedule, yeah.
And so let's talk about when you actually went down to go work for the zoo. Now, after conducting your initial inspection, you were provided the original construction report?
No, that was after my original inspection. I had to get it to make sure that.
And you got it from Jordan Hastings?
Yes, I compared the diagram of the observation deck to the actual observation deck as a part of my second inspection, wherein I required that the observation deck be closed.
Now, let's talk about this original construction report that you got from Jordan. When you got this report, you saw that on it was listed Bailey Westfall's name, correct?
Yes, Water and Westfall LLC is actually a construction company. To build and design a fence, you really need some sort of expertise in engineering. It's a different type of expertise. It's incredibly dangerous if you don't have that type of knowledge and understanding of structures in general to build something like that, which is why that raised some concerns, as well as many other factors in the diagram.
Right, Ms. Reynolds, but you don't work with Water and Westfall, do you?
No, I work for myself, Harper.
You don't know their specific credentials as a result of this, correct?
I know that they're a construction company.
Right, but you don't know the different thorough steps that they may take in constructing a structure?
I saw their diagram, which outlines how they built the structure, and it shows how they were secured in the ground. The plans are what shows you how safe something is, which is why I decided that it wasn't safe.
All right, so let's talk about why you decided it wasn't safe. Now, in your assessment of this fence, you never checked the density of the wood, did you?
Wood is a type of, it's a softwood, but the thing about wood is that it falls apart. It's outside, zoos are outside. And so when it's subjected to the elements, there's a tendency to rot, and that's incredibly dangerous. The protective stain on this particular fence had completely washed away, so I could see how it was splintering and how it was rotted, and that really raised some red flags for me.
I appreciate that, Ms. Reynolds, but back to my question, you never checked the density of this wood, correct?
I didn't have it's kind of hard to check the density of a wood. There's a lot of special pressure.
Right, but you would agree that the composition or the material of the fence would contribute to its structure?
I mean, it's wood. There's some very scientific tools that we would have to check that. That doesn't really play a major role in different densities of wood. It's really just that it's wood is what makes
Just to clarify for the jury, you didn't use these scientific tools in your inspection?
No, I'm a structural engineer. I don't need to do that. We were taught that wood outside is incredibly dangerous, especially when it's so high up. You need something that's secure in the ground, many feet in the ground, so that it doesn't fall apart.
Right. And just one more question. When assessing this wood, you never acknowledged that it was redwood, did you?
No, I did not.
You never acknowledged redwood's elasticity?
No, I did not. It's wooden though, which is incredibly dangerous because it had completely rotted.
Thank you, Your Honor. I have no further questions.
Will there be a redirect to this witness?
Yes, Your Honor, very briefly. Ms. Reynolds, why did you not check the density of the wood?
I didn't check the density of the wood because that's not a factor in determining if it's safe or not. All wood has a very similar density. The fact of wood just isn't a very safe material to protect people from danger, especially when wild animals are involved. You really want to make sure that safety is the top priority in these cases.
So what factors did you take into account when you were inspecting the structure?
Well, how it was constructed, it wasn't very secure in the ground, how the beams connected to the posts, and how the protective stain was completely washed off, and the height especially was a very large factor in this.
Thank you, Your Honor. No further questions.
Will there be a recross of this witness?
Yes, Your Honor, very briefly. Now, Ms. Reynolds, you talked about the wood in your inspection in your redirect examination. Now, you never acknowledged that the particular wood on the fence at the baboon exhibit was supposed to bend and shift, did you?
Structures shouldn't shift that much because they're supposed to be stable. The stability of a structure is really important to make sure that it doesn't let people fall. If it moves, that means that it's not stable, no matter what material it is, especially when people are trying not to fall off.
I appreciate that, but that's a yes to my question that you didn't acknowledge that this particular type of wood was supposed to bend and shift.
I acknowledge that it did bend and shift, but I don't think that I acknowledge that wood is so dangerous that it does do that.
I have no further questions, Your Honor.
Thank you, counsel. Witness, you may step down. Is the plaintiff prepared to call his next final witness?
Yes, Your Honor. The plaintiff calls Lee Stevens to the stand.
You have 6 minutes and 55 seconds for your final direct.
Please state your name and occupation.
Hi, I'm Lee Stevens, and I'm a freshman at Continental State University.
And Mr. Stevens, prior to attending CSU, where'd you go to school?
Well, I went to McConnell High School, but I'm never going back. You know, people say it's the closest thing to heaven on earth. Can you believe that? I've lived there since I was born, but people still make up rumors about me and Tommy.
And how did you know Tommy Thompson?
Well, Tommy was my best friend. We did everything together. Luckily, we even had Carpenter's class together. It's really the only reason the class was enjoyable.
And what is your relationship with Mr. Taylor Carpenter?
Well, Carpenter never seemed to like me and Tommy that much. On the first day of class, he snapped at me and Tommy and told us that he was warned about us. It was crazy. We've never even talked to the guy before. So we always figured he'd get it out for us.
And were there any incidents in his class?
Well, yeah, like there was this one time where basically it was this stupid prank that we pulled, but I filmed Tommy jumping out of the window. No one got hurt, but we still got yelled at by Principal Parsons and Carpenter, and I got yelled at by my parents. I swore to all of them that I wasn't going to do anything like it ever again.
Moving on, what was going on November 20th?
Well, that's when we went on the biology trip to the zoo. And of course, Tommy's dead.
And what happened when you first arrived at the zoo?
I met our tour guide, Avery Fields. It was actually a pretty fun trip at first. Me and Tommy had fun going around, making faces at all the animals. Then we got to the observation deck, and then we got to the baboon exhibit, and Avery told us we could go down to the observation deck. So that's exactly what me and Tommy did.
While you and Tommy were at the zoo, did y'all have any plans to film a click-clack?
No, I was already reprimanded once, and I was too scared. So I promised that I wouldn't do anything. And Tommy promised me that he wasn't gonna film anything. I'm his best friend. He wouldn't lie to me.
And
Your Honor, hearsay.
Your Honor, can I request that my opposing counsel elaborate on what exactly part of this statement is hearsay?
Yes.
Yes, Your Honor. This witness clearly stated that Tommy Thompson told him, he promised, in fact, that he would not film a click-clack that day at the zoo, which is an out-of-court statement pursuant to Crenshaw v. Roth.
Your Honor, may I respond?
You may.
In accordance with 8033, this is the mental state of the witness here today, and therefore it is admissible.
Your Honor, may I respond?
You may.
8033 is not applicable in this situation because Tommy Thompson's specific intentions in regards to his actions that day are not a mental state. A mental state would be something like a feeling. This specific instance does not fall under this exception and cannot be used in this instance.
Your Honor, may I respond?
Yes, briefly.
8033 is exactly what we should be referencing here. This is the mental state of Lee Stevens, and it is exactly what he was feeling in that moment. It is his recollection of that moment, and it is not hearsay because of 8033, which allows for that mentality and that mindset at the time of the incident to be taken into account today.
Your Honor, may I respond?
Yes, briefly.
The mindset in this case that is important is Tommy Thompson's. Mr. Stevens cannot testify as to how Tommy Thompson was feeling at the time, nor can he use this hearsay to establish any type of plan because that simply does not fall under 8033. Any mental state that Mr. Stevens can be testified to is only his own, and any attempt to do so for Mr. Thompson does not fall under 8033 and is not admissible.
I tend to agree, counsel, so I'm going to sustain the objection. Just for some clarification, the bailiff showed the wrong time card. They have exactly 5 minutes left for this direct. So you may continue when you're ready.
So just to clarify, what happened, who was your tour guide while at the zoo?
Yeah, it was Avery Fields.
And where did she take you in the zoo?
So when she took us all around the zoo, and then we got to the baboon exhibit, and she told us we could go down to the observation deck. So that's exactly what me and Tommy did.
Would you recognize a version of the observation deck I've seen today?
Yeah, I would.
Your Honor, would the bailiff please screen share exhibit number 4, which has been previously entered into evidence in accordance with stipulation 9?
Yes, counsel.
And may I hand my witness a clean copy after showing my opposing counsel?
You may.
What is this document?
Well, it looks like a copy of the baboon observation deck, or a diagram of it.
And Mr. Stevens, what were you doing right before the accident?
Yeah, so me and Tommy were right here on the observation deck. We were watching click-clacks on our phones when all of a sudden the railing under Tommy's arms, it slipped and he fell into the exhibit below. I tried to reach for him, but it just happened too fast.
Thank you, Mr. Stevens. The bailiff can stop screen sharing that exhibit. Did you see any warning signs before the fall?
No, I didn't see anything, no.
Your Honor, at this time, would the bailiff please screen share exhibit 3, which has been previously entered into evidence? Do you recognize this document?
I'm sorry.
Yes, Your Honor. I have an objection to lack of personal knowledge.
Your Honor, may I respond?
You may.
This is not, I'm not attempting to probe the witness necessarily on the contents of this document, but whether or not they are familiar with it. And that is extremely important in today's case when we're trying to understand the zoo's liability. And seeing that Lee Stevens was on the field trip at the Robinson Zoo, they were, his recollection of whether or not he saw any signs ties directly to whether or not the zoo is liable. Once again, I'm not trying to probe the witness's knowledge of this document, but rather whether the witness is familiar with it.
Your Honor, may I respond?
You may.
The purpose of introducing any piece of evidence such as this one is in order to authenticate it. If my opposing counsel is not attempting to enter this document, then he should not be showing it to the witness.
Your Honor, may I respond?
Very briefly.
In accordance with stipulation 9, this has already been entered into evidence. Therefore, I'm not attempting to admit it. I'm just simply trying to probe the witness on whether or not they are familiar with it.
Your Honor, may I respond?
No, counsel. I'm going to overrule the objection for now. But if you feel that counsel is asking questions about the content of the exhibit and rather what they are attending now, then you may object again.
Yes, Your Honor.
Would you like me to repeat the question?
Yes, please.
So have you ever seen this document before?
No, I haven't.
Would the bailiff please scroll to the second page? How about this document? Are you familiar with this?
Not this one either, no.
Did you see either of those documents posted around the zoo?
No, I didn't see anything like that, no.
Well, Mr. Stevens, did you see any signs warning you to the aggressive nature of Junior the baboon?
Objection, Your Honor. Relevance.
Your Honor, may I respond?
Yes.
In accordance with Wagner v. ABC Toys, the zoo is, today we're supposed to examine the liability of the zoo. And this ties directly to whether or not the zoo is liable. Wagner v. ABC Toys tells us that the zoo needed to warn of any known dangers. Seeing that Junior the baboon was described in a report as being vicious, he is a known danger, and therefore the zoo would need to notify guests of him. And therefore it is extremely relevant in today's case. We'll find while we're trying to discuss whether or not the zoo is liable.
Your Honor, may I respond?
You may.
Pursuant to Hens v. AV and pretrial order 2, this case has been bifurcated into two parts, one of liability and one of damages. Any discussion of Junior the baboon or any actions he had taken against any of the guests would go towards the damages part of this section and not be used in this particular part of trial.
Your Honor, if I may be heard.
I'm sorry, counsel. I tend to agree with the defense. I'm going to sustain the objection.
Yes, Your Honor. Mr. Stevens, was there any adult supervision at the time of Tommy's fall?
Well, I looked around for Avery Fields, but she wasn't anywhere in sight. I wish someone had been there to stop Tommy.
Thank you. No further questions at this time, Your Honor. I'd look to reserve the remainder of our time.
Thank you, counsel. Will there be a cross to this witness?
Yes, Your Honor. Before I begin, I'd just like to make sure that both the witness and Your Honor can see and hear me clearly.
Yeah, we're good.
Yes. You have, for clarification, I'm sorry. You have 3 minutes and 40 seconds remaining.
Yes, Your Honor. Mr. Stevens, before we begin, I'd like to acknowledge that this may be hard for you to talk about, but I'm sorry, I'll have to ask you a few questions. Is that all right?
Yes, that's fine.
I understand that you and Tommy were avid users of the app ClickClack. Is that correct?
Yeah, that's right. Yes.
And Tommy often posted his stunts on the app, right?
Yes, that's right.
You were
Although,
worried. Oh, I'm sorry.
to be fair, like we definitely engaged in some like theatrics going on. So like in the stunt that I described earlier, like that they did, the TikTok ClickClack users didn't know that it was just the first floor. So there's a bit of theater, going on. But yes, continue.
I understand. But you were worried about the dangerous nature of some of these ClickClacks, were you not?
Yeah, that's right. I got onto him about it. His mom got onto him about it. We were worried about him. Yeah.
All right. And when Tommy posted the video of him jumping out the window, he gained quite a few followers on ClickClack, did he not?
Yeah, we didn't expect to blow up that much after that, but yeah, that's what happened.
And after he blew up on ClickClack,
he began posting the latest trends every week.
That's right.
And he would record these trends on Wednesdays and then post them on Tommy Thursdays, right?
Yes.
And his moniker on the app was Treacherous Tommy, wasn't it?
Yeah, that's something all the the viewers like built up and gave to him. It wasn't something that we came up with. We didn't expect it, but yeah, that's what happened.
Right, and in fact, Tommy even told you that it didn't matter how dangerous a stunt was. If it got him more followers, he was going to do it, didn't he?
Yeah, like I said, me and his mom got onto about it. It really got to his head. Luckily, that never ended up being an issue, but yeah, he got to him.
Right. Now on November 20th, the week of November 20th, the handstand challenge was trending on ClickClack, wasn't it?
That's what King John, yeah, he posted that. It became a little trend. Yeah, it was like the weekly fad. It is.
And November 20th was on a Wednesday, was it not?
Yeah, that's right. Although Tommy promised me, and I'm his best friend, he wouldn't lie to me. He wouldn't have lied to me. That he wasn't going to film anything at the zoo.
But it was the normal day for him to be filming a ClickClack, was it not?
That's correct.
Now at the zoo, you and Tommy went down to the baboon exhibit, correct?
Well, yeah, we went down to the observation deck, right?
And one of your classmates, Drew, also went with you?
Yeah.
And at the fence, Drew actually leaned over the railing, didn't he?
Yeah, so what happened is like he leaned over it and then like Avery like yelled at him and told him to get back because it was dangerous and all. But then she clarified, she was like, it's good to lean on it, which we now know is untrue.
So now Avery did warn you about the fence, correct?
Well, she said we can lean on it. She said we could rest our arms on it.
And when Drew leaned over the fence, it didn't break, did it?
Well, yeah, he just leaned over it. So. Didn't rest his arms on it. So.
Now, on that day on the field trip, you were instructed by your teacher, Taylor Carpenter, not to have your phone out. Is that correct?
That's correct.
But what you did that day on the field trip at the baboon exhibit was you watched the handstand challenge.
I mean, yeah. Tommy just told me about it, so I wanted to check it out. So I'll watch the video.
No further questions, Your Honor.
Go ahead. Sorry. We're good.
Thank you, counsel. Will there be a redirect for this witness?
Yes, Your Honor, very briefly. Mr. Stevens, can you remind me what exactly happened at the baboon exhibit?
Yeah, so we go down to the observation deck. Tommy tells me that King John just posted a new video on ClickClack. I pull out my phone.
Your Honor, hearsay?
Your Honor, may I respond?
You may.
Your Honor, this is not hearsay, seeing that it's the witness's rationally based perception of the events which occurred on the baboon exhibit. Seeing that Lee is an eyewitness to the events which occurred, he is not necessarily attempting to, or this line of questioning is not attempting to probe an out-of-court statement from the witness that would negatively impact the jury's perception of the situation, but rather just attempting to understand what occurred on the baboon exhibit.
Your Honor, may I respond?
You may.
There was an out-of-court statement elicited when the witness said that Tommy told him to check his phone out and watch the new handstand challenge. This is what I'm objecting to, not the general line of questioning.
Your Honor, may I respond?
Yes, briefly.
I once again call in 8033, which is we're discussing the mental state of Lee Stevens at the time of the baboon exhibit and the issues regarding that. This is the then existing mental state of Lee Stevens, and therefore it is admissible.
Your Honor, may I respond?
Yes, one more time.
The mental state of Lee Stevens in this case is not applicable. It was the statement made by Tommy Thompson that I'm referencing that is considered hearsay pursuant to Crenshaw v. Roth. Lee Stevens' own personal feelings or sentiment about the situation does not help to exclude the statement that he made, that Tommy Thompson made from a hearsay objection.
Your Honor, if I may just rephrase the line of questioning that would probe a different area of the witness's knowledge.
Thank you, counsel. I'm going to sustain the objection then.
Mr. Stevens, what happened on the baboon exhibit in regards to what you were told from your tour guide?
Yeah, so we were told we could, well, so down there the first time, Drew walked over and leaned over the fence, and Avery like freaked out and yelled at him, told him to get back, and told him that it's fine to like rest your arms on it, but you can't lean over it because it's dangerous.
But did she, where was she when Tommy fell?
She was nowhere. I looked around for her, but I couldn't see her.
So at the time of Tommy's fall, there was no adult supervising from the zoo?
That's right.
Thank you, Your Honor. No further questions.
Will there be a recross of this witness?
Your Honor, may I inquire as to how much time I have remaining?
You have 15 seconds.
Yes, Your Honor, very briefly. Mr. Stevens, just to clarify for the court, when Drew leaned over the fence, it didn't break, did it?
Well, he wasn't resting his arms on it, so no.
No further questions, Your Honor.
Thank you, counsel. Witness, you may sit down. Does the plaintiff have any further witnesses?
Your Honor, the plaintiff rests.
Is the defense prepared to call its first witness?
Yes, Your Honor. At this time, the defense calls Mr. Jordan Hastings to the stand. Before we begin, can both Your Honor and our opposing counsel see and hear both myself and the witness clearly?
Yes.
Could you please introduce yourself for the court?
My name is Jordan Hastings, and I've been the manager at the Robinson Zoo since 2014.
Why zoo management?
Well, growing up, I always wanted to be a zookeeper, and when I was in high school, my parents caved and let me attend a zookeeper camp, where unfortunately I found out I was allergic to half the animals. I decided that in order to keep my allergies in check, I would have to go into zoo management instead.
And how did you begin this career?
Well, I attended Carrington College, where I double majored in business administration and zoology, while also working as an intern for the Robinson Zoo. I studied hard and made good grades, and by the time I graduated, that management position opened up, and I've been there ever since.
What's it like in this position?
They say if you love your job, you never work a day in your life, and that's absolutely true. Working at the Robinson Zoo is very rewarding, but the close proximity with wild animals has some complications. That's why we make sure to make safety our top priority. One of the ways we do this is through the Robinson Zoo Tour program. Not only is it great for business, but it helps create a more safer, engaged community.
And what's the Robinson Zoo Tour program?
For an additional fee, customers can have a tour guide lead them through the zoo and explain the animals and the exhibits. It requires pretty extensive knowledge of the zoo itself, so there's a lengthy training course.
What does the training entail?
Well, on top of the training that all employees must undergo, which covers crisis management, CPR, safety protocol, the whole 9 yards, the tour guides are also tested on the animals around the zoo so that they can, talk about them. It lasts about 3 weeks, and at the end there's a checkout session, which all of my employees passed, some more easily than others.
What do you mean by that?
Well, one of my employees, Avery Fields, seemed to struggle with the program at first, and she failed the checkout session twice. I saw promise in Avery, so I decided to give her a third and final try, where she eventually passed.
And after Avery passed this final checkout session, what happened?
Well, things at the Robinson Zoo were business as usual up until the week of November 10th.
What was different about that week?
Well, it was just a lot busier than usual. We had a few animals sick, and on top of that, we had an inspection from the Continental Zoo Association. They sent Harper Reynolds to come and inspect the facility to make sure that everything was structurally sound. And given that safety is my top priority, when Harper made some recommendations, I was happy to fulfill them.
What was the first recommendation given to you?
Well, Harper seemed to take issue with the observation deck of the baboon exhibit, so she said that I needed to post warning signs and close the exhibit temporarily. I immediately did this, as well as I sent out an email and held a staff meeting to notify my employees that the exhibit would be temporarily closed.
And would you recognize these warning signs if I were to show them to you?
I would.
Your Honor, at this time, I request that the bailiff please screen share what has been pre-entered under stipulation 9, exhibit 3. I'm also providing my witnesses a paper copy. Let the record reflect we are showing both sides to the camera. Do you recognize this?
Yes, these are the warning signs that I posted all throughout the zoo.
And are they fair and accurate?
They are.
So what do these signs communicate?
Well, they just indicated that it was okay to rest your elbows or even lean on the railings, but at no point should you be standing, climbing, or God forbid, doing a handstand on the railing. Anything that would require your full body weight from above. I thought this was pretty obvious, but we have a lot of teenagers that come to the zoo and they can be pretty unpredictable. So I wanted to be extra careful.
So where did you post these signs?
All throughout the zoo, including the observation deck of the baboon exhibit.
And bailiff, at this time, I request that you stop screen sharing. So now, what was the second recommendation Harper Reynolds gave you?
Right. She also said I needed to have a licensed contractor come and give a follow-up inspection, and then, if necessary, make repairs around the zoo.
Did you fulfill this?
Absolutely. I called Bailey Westfall to come and complete the inspection. We've worked with Bailey since, well, as long as I've been at the zoo. She's very reliable, and she even built the fence herself. So I figured who better to come and complete the inspection.
So what did her inspection reveal?
Well, she actually told me that the fence was okay and not in need of repair. I was
This is hearsay under Rule 801, set by the precedent of Crenshaw v. Roth. This is an out-of-court statement by Bailey Westfall, which should not be entered today.
Your Honor, if I may.
You may.
We are not offering this statement for the truth of the matter, rather on the effect of the listener, making it admissible as non-hearsay.
Counsel, do you have a response?
Yes, Your Honor. Under Rule 801, this is still an out-of-court statement, seeing as this is talking about the truth of the matter, but it shouldn't be admissible, seeing as this is not, there are no exceptions to hearsay which would allow for this statement to be entered, seeing as Jordan Hastings did not have the experience of Bailey Westfall, nor knew what was Bailey Westfall was thinking. So any remarks by Bailey Westfall should not be said by Jordan Hastings, and is still an out-of-court statement and should not be admitted.
Your Honor, if I may very briefly.
Yes.
Definition of hearsay under Rule 801 is an out-of-court statement asserted for the truth of the matter. It's two-pronged and needs both of those prongs to qualify as hearsay. This statement isn't being offered for the truth of the matter. It's rather being offered for the effect on the listener to show how Mr. Hastings responded to Bailey Westfall's inspection of the baboon observation deck. Therefore, this testimony is admissible as non-hearsay.
Your Honor, may I
That's
respond?
in. I'm sorry, counsel. I tend to agree with the defense. I'm going to overrule the objection.
So what did Ms. Westfall say?
Well, she just said that the fence was fine and not in need of repair. And I was thrilled, and I planned to email Harper right away. But Bailey told me that that wouldn't be necessary and she could talk to Harper herself. And I figured it was best to let the professionals handle this amongst themselves.
Of course. And after Bailey told you it was safe to reopen the baboon observation deck, did you take any further safety precautions?
Yes, I decided to keep the warning signs posted on the exhibit as well as the rest of it. I also sent out an email to my staff and held a meeting to let them know that the exhibit would be reopened, but they still needed to enforce all of the rules.
Did Avery Fields attend this meeting?
She did, and I reminded her of all the rules that she needed to enforce.
So when did you see Ms. Fields next?
It was the next day, November 20th, around 11:15. She came into my office and she looked like she'd seen a ghost.
Did you find out what was wrong?
Yes, Avery explained that during one of her tours, the fence of the baboon exhibit had broken and a student, who I now know to be Tommy Thompson, had fallen into the enclosure. I was in complete shock for several reasons.
What were these reasons?
Well, first and foremost, this is a complete tragedy and my heart goes out to the Thompson family. Second is just how easily this tragedy could have been avoided.
Mr. Hastings, what do you mean by that?
At the Robinson Zoo, we work hard to make safety the top priority. We do this through.
Objection, Your Honor. This is opinion on ultimate issue, seeing as Jordan Hastings talking about whether or not the incident could have occurred is discussing the ultimate issue of whether or not Robinson Zoo is liable today.
Your Honor, if I may.
You may.
Pursuant to Rule 704, opinions on the ultimate issue are automatically admissible and only inadmissible when offered by an expert and during a criminal case. Mr. Hastings is not an expert, and we are today trying a civil case, making this not an opinion on the ultimate issue.
Counsel, you may respond very briefly.
Being as ultimate issue this is still talking about the ultimate issue of the case, and what Jordan Hastings may say as a lay witness could influence the decision of the jury. Seeing as the Jordan Hastings outside opinion of the responsibilities of the zoo would affect the jury's opinion on whether or not the zoo is negligent, this is still like opinion on ultimate issue and should not be talked. This line of questioning should not be discussed today.
I'm going to overrule the objection. Thank you, counsel.
So what were these reasons?
Well, we work hard to make the Robinson Zoo a safe place. This is possible through extensive safety protocol, safety meetings, and warning signs. I mean, we had the fence inspected twice before we made the decision to reopen. I just can't fathom how reasonable action could have contributed to something like this.
Thank you, Your Honor. No further questions.
Will there be a cross to this witness?
Yes, Your Honor. Before I begin, Your Honor, can you hear me okay, as well as Jordan Hastings?
I'll get here.
Perfect. Now, Jordan Hastings, you said that you would never cut corners when it came to safety, correct?
Of course, safety is always the top priority at the zoo.
Yet, when Avery Fields failed the necessary tour guide training program, not once, but twice, you still let her become a tour guide, correct?
Well, yes, I think people learn at different paces. And since she eventually passed the program, I concluded that Avery was qualified.
And so you had said you warned your guests of all known dangers, correct?
We did.
But when Harper Reynolds instructed you to put up warning signs, you used old warning signs instead of new ones, correct?
Well, Harper never specified anything about the warning signs. She just said warning signs in general. So the ones I had, to my knowledge, were sufficient in warning our guests not to climb on the railings or do anything of that nature.
Thank you. Now moving on to the week Reynolds inspection. Because a lot of animals are sick, that was a large financial expense to the zoo, correct?
All right, nobody wants to pay to come and see animals sick and lying around, but obviously that's not a top priority. We're much more concerned about the safety of the animals, employees, and customers.
Yes, and when Harper Reynolds instructed you to get a licensed contractor, you didn't check to see if Bailey Westfall was licensed by the Continental Zoo Association, correct?
I never verified with Harper that she was licensed, but she was in fact licensed by the Continental Zoo Association to complete this inspection.
But to clarify, you never checked that she was licensed?
No, I never checked with Harper about this.
Thank you. And when Bailey Westfall sent you her report, she sent an invoice along with it, correct?
I'm sorry, could you repeat that?
When Bailey Westfall sent you her report, she sent an invoice along with it, correct?
Right, which was the estimate if I wanted to complete the repairs, but she also said that it wouldn't be necessary.
Thank you. Your Honor, would the bailiff please screen share Exhibit 9?
Exhibit 9.
Yes.
No.
I think this is Exhibit 10.
Give me a second. It won't let me switch, but your time is stopped right now.
No worries.
Would I also be allowed to have a paper copy of this? It's a little hard to read on the screen.
Yes, counsel.
Thank you. Now, Ms. Hastings, do you recognize this document?
I do.
And has it been changed or altered in any way?
It does not appear to have been.
And do you think it's a fair and accurate copy?
Yes.
Your Honor, the plaintiff moves to enter Exhibit 9 into plaintiff evidence.
Are there any objections?
Yes, Your Honor, to both hearsay and more prejudicial than probative.
Which one are you objecting to?
More prejudicial than probative, Your Honor.
Is there a response?
Yes, Your Honor. Under more prejudicial than probative, this is severely probative in this case, seeing as when the line of questioning, if my opposing counsel would let me continue my line of questioning, this document and interview evidence would be very crucial to the question at court today, seeing as whether or not a financial obligation may have been the reason why the fence was not fixed, would be the reason why the zoo breached the duty of care, seeing as the question today is the liability of the zoo and whether or not the fence itself was fixed is part of this liability and duty of care, which the plaintiff has to prove today. This exhibit is severely much more probative than prejudicial.
Your Honor, if I may.
You may.
Pursuant to Jamie v. Granger, we are here today to decide whether the Robinson Zoo breached their duty of care and directly and proximately caused the death of Tommy Thompson. And this does not constitute anything in regard to motivation. Motivation alone is irrelevant in this case, and the money motivation could possibly prejudice the jury against Mr. Hastings, especially considering that he never even had to pay these expenses because the fence was structurally sound.
Your Honor, may I respond?
Very briefly.
If the opposing counsel would have looked at the general allegations of the case, whether or not the zoo fixed the fence is very crucial to the negligence at hand, seeing as the duty of care would be in fixing the fence and is stated in the general allegations of the case. whether or not the zoo fixed the fence is very probative in this case, seeing as I previously stated, this exhibit would call to question why the zoo didn't fix the fence is very, very important in this round.
Thank you, counsel. I tend to agree that the opposing counsel hasn't met the burden for more prejudicial than probative, so I'm going to overrule the objection. It is so entered into evidence.
Would the bailiff please scroll down to the total of the invoice? Thank you. Mr. Hastings, the total, if the fence was to be fixed, would total $7,649.83, correct?
That's correct.
And this would have conflicted with any financial obligations that you previously agreed with, correct?
Well, we had Harper recommend a second opinion. So when that second opinion told me it wasn't necessary, I decided not to do it. If it was necessary, I would have had no hesitation to complete this repair.
But so you would still agree that if you had needed to complete this repair, which you neglected to do, that it would have conflicted with the other financial obligations of that week?
I mean, it would have costed money, but I don't know exactly what you mean by conflicted with the financial obligations. But yes, we would have had to pay that to fix it, and we absolutely would have if it were necessary.
So looking at the previous financial obligations with sick animals you already agreed to in this examination, this would have conflicted monetarily with the zoo, correct?
Right. Running a zoo, you have to pay for certain things like this, but since this was not deemed to be necessary, it wasn't an issue.
Thank you. Now, Mr. Hastings, one final question for today. When you describe Avery Fields was an employee of the zoo at the time of the accident, correct?
That's correct.
Thank you, Your Honor. No further questions.
Thank you, counsel. Will there be a redirect to this witness?
Yes, Your Honor, very briefly. All right, so my opposing counsel recently talked about Exhibit 9, so I'd just like to ask you a few questions about it. Did you have to pay the $7,000 fee?
No, I mean, it was under the advice of 2 inspectors that this was not absolutely necessary, so we never had to make this payment.
And finally, was closing the baboon exhibit after Harper Reynolds' inspection in the zoo's best financial interest?
I mean, if it was necessary, we would have done it, no doubt. This was not a big issue to pay. The fact of the matter was that we didn't need to pay this.
Thank you, Your Honor. No further questions.
Will there be a recross to this witness?
No, Your Honor.
Witness, you may step down. Is the defense prepared to call its next witness?
Yes, Your Honor, the defense calls Ms. Bailey Westfall to the stand.
You have 12 minutes and 30 seconds.
Your Honor, before we begin, can you and opposing counsel both see and hear Ms. Westfall clearly?
Yes, counsel.
All right, may I proceed, Your Honor?
Yes.
Could you please introduce yourself to the court?
My name is Bailey Westfall.
And what do you do for them?
Currently, I'm a contractor and the co-owner of Vaughter & Westfall LLC.
And what kind of work do you do then, Ms. Westfall?
Well, our company works on both commercial and residential properties. And as a contractor, I design structures, I gather the proper materials for building, I conduct regular inspections, and of course, I build things too. Our company deals with pretty much anything construction related. I mean, you name it, we do it.
And what kind of education do you have?
I have a degree in construction science from Continental State University.
What did you do after college there?
Well, I had absolutely fallen in love with Rockville, so after college, I wanted to stay in the area. I got a job shadowing Susan Vaughter, who is a renowned contractor, and eventually we started Vaughter & Westfall, which is where I've been for the past 14 years.
Your Honor, at this moment, we move to tender Ms. Bailey Westfall as an expert in the field of construction science.
Are there any objections?
No objection, Your Honor.
She is so entered.
Now, Ms. Westfall, what kind of work were you doing as of November 2019?
Around that time, I was working with the Robinson Zoo.
And how long have you been working with them?
Our company's been doing work for them for the past 14 years. Over that time, we've done many jobs and inspections, and I'm actually licensed by the Continental Zoo Association to make inspections and do repairs.
And what kind of work were you doing for them during that November?
Well, the Robinson Zoo called me and asked me to provide a second opinion after an inspector had recommended the installation of a new fence on one of their exhibits.
Which exhibit was this?
The baboon exhibit.
Would you recognize a diagram of it?
Yes, I would.
Your Honor, I request that the bailiff please screenshot what has been pre-admitted as Exhibit 4 according to Stipulation 9. And I also ask that I be allowed to share a physical copy with my witness.
That is your right.
For opposing counsel. Ms. Reynolds, What is this diagram?
This is a diagram of the baboon exhibit.
And could you tell the jury a bit about this exhibit?
Of course. So Bonner and Westfall actually remodeled this exhibit. And when we did, we installed a brand new fence on the observation deck. We used redwood because it's much stronger than other materials and it lasts significantly longer.
Bailiff, could you please scroll to page 2? Now, Ms. Westfall, what can you tell us about the structure of this fence?
So you see that the fence is made out of 3 different pieces. You have the 2 posts on either side that are inserted half a foot into the ground just to provide extra stability. And you also have the fence slat, which is this horizontal rectangular piece here. And that's in place just to keep anyone from falling into the enclosure below.
Thank you, Ms. Westfall, and thank you for screen sharing, Bailiff. Now, Ms. Westfall, as far as you knew, were there ever any issues with this fence?
Not to my knowledge, there hadn't been any problems with it in the past 14 years. And it passed every inspection up until November of 2019.
So what was your opinion of this fence?
Well, after I inspected the fence, it was clear that it didn't need to be replaced. I mean, it even had another 2 to 3 years of life on it. I understand that a 14-year-old fence sounds concerning, but given the proper use, that thing would last for decades.
What do you mean proper use?
Well, the fence is made out of redwood, so it can endure a lot. And the redwood aspect matters because it most importantly maximizes safety, but let's be honest, it's also aesthetically pleasing. To add on to that, we also stained and sealed the deck, just to add an extra layer of protection.
Now, were there any other safety measures taken when you constructed it?
Of course, in addition to the sturdy fence posts, we added the fence slat. This ensured that the fence was as safe as it could be. The only way it could have possibly posed any issues is if someone were to use it improperly.
Improperly? Could you explain to the court what you mean by that?
So direct pressure on top of the frame would constitute improper use of the fence. Only unreasonable actions such as standing, handstanding, basically placing your entire body weight on the fence could have posed any issues. Something like leaning on the fence, for example, would be completely fine.
And how did you arrive at these conclusions?
Well, I inspected the fence myself, and when I did, I noticed that there was no evidence of structural damage, decay, or anything of that sort. I also looked at a copy of the original inspection report. I noticed that there's no mention of the material being tested, its density, its tensile strength, or even something as basic as torque. And honestly, I was a bit confused about the test that the inspector used.
Why were you confused about the test?
Well, Harper Reynolds conducted the initial inspection, and in it, she only leaned on the fence, and from that, she deemed it to be unsafe. However, this test makes no sense because the fence was made out of redwood, which is an elastic material.
Now, Ms. Westfall.
Under Rule 404, this is improper character evidence of Ms. Harper Reynolds.
Your Honor, may I ask the opposing counsel to elaborate as to how this is an improper character evidence of Ms. Reynolds?
You may.
Pursuant to like pretrial orders, Ms. Reynolds is this line of questioning is going against Ms. Reynolds' line of expertise, as is calling into question that her test was bogus and not real, and therefore it is improper character evidence under Rule 404.
Your Honor, may I be heard?
You may.
Improper character evidence is only viable when there is a character trait being elicited. Ms. Westfall is simply talking about the test that she reviewed. She's not posing a particular character trait on Ms. Reynolds, but rather just her observations, and she's applying her own expertise. And she is not degrading the expertise of Ms. Reynolds, but simply talking about what she observed and how she applied what she knows.
Your Honor, may I respond?
I'm sorry, I froze again.
May I respond?
You may.
Pursuant to Hope v. Grant, this is improper character evidence, and seeing as the jury is taking what Ms. Bailey Westfall is saying about Harper Reynolds' test as the truth of the matter, it is improper character evidence under Hope v. Grant and under Rule 404.
Your Honor, may I be heard briefly?
No, counsel, I tend to agree with the defense here. I'm going to overrule the objection. Please continue with your line of questioning.
Yes, Your Honor. So, Ms. Westfall, you were talking about redwood being an elastic material. Could you explain to the jury what significance this has?
Of course. So redwood is meant to bend and shift slightly. That's how it's supposed to work. Think of the redwood trees in California, for example. When the wind blows, they bend and sway, and you can even hear them creaking, but they never actually break. This is because of redwood's elasticity, and this elasticity lends itself to the material's overall longevity.
Now, what did you do after inspecting the fence at the baboon exhibit that day?
Well, I followed up with Jordan Hastings, the zoo manager, and I cleared the reopening of the exhibit based on my conclusions. It was clear to me that the fence did not need to be replaced. Only improper use could have caused any problems, and only unreasonable actions could have resulted in a tragedy such as this one.
Thank you, Ms. Westfall. Your Honor, I have no further questions.
Thank you, counsel. Will there be a cross to this witness?
Yes, Your Honor.
You have 8 minutes and 42 seconds.
May I proceed?
You may.
Ms. Westfall, because the Robinson Zoo was your first ever solo project, you would say you have a very close working relationship with them, correct?
Well, not just because it was my first solo project, but we've been working with them for a long time. And when you work with someone for that long, you get that client contractor relationship. And I have that relationship with other clients too, not just the zoo.
You built them a fence with 4 feet slats, yes?
Sorry, could you repeat that? They cut out at the beginning.
You even built them a fence with 4 feet slats, correct?
Well, it was made out of 3 main pieces. You had the 2 fence posts and then the fence slat in the middle.
Right, but yes, that is a yes to my question, yes?
Yes.
Will the bailiff please screen share Exhibit 4, which has been pre-entered into evidence pursuant to Stipulation 9? Scrolling to page 2, please. So Ms. Westfall, you would say that having an accurately sized diagram is critical to safety in your line of work, yes?
Yes, it is important.
And just a couple minutes ago, you described your fence's slat as 4 feet, yet in this diagram, they're marked as 3 feet. Are they not?
Well, the 4 feet, the 4 foot measurement that I give in my statement includes that beam that you see on top of the fence slat. So really they're 2 different measurements because that beam adds an extra foot to the height.
But in your affidavit, it specifically says that the fence's slats are 4 feet, correct?
Well, the slats including the beam. I apologize. I thought that would have been clear.
Okay, so that is a yes to my question. So moving on, when the Robinson Zoo called you, or when the Continental Zoo Association called you, Jordan Hastings indicated that closing down the exhibit could financially ruin the zoo and even begged you to help, yes?
Yes, he did.
And but before you even read the report, you immediately rolled your eyes when you saw Harper Reynolds' name?
Well, that was a bit of an overreaction, I would admit, but nevertheless, it was justified because in Harper's inspection, she only leaned on the fence, but that test makes no sense because of Redwood's elasticity.
This was before you read her report, yes?
Well, I rolled my eyes when I saw the report itself.
Thank you. And then you even indicated that you would have never even made a trip to the zoo if you knew that Harper was the one who inspected the fence?
Again, that was a bit of an overreaction, but nevertheless, I did go to the zoo and I did perform my best work.
But you would have told Jordan Hastings that everything was okay without making an inspection yourself?
Again, I said that it was a bit of an overreaction, but regardless, I did go to the zoo and I inspected the fence to the best of my abilities.
But you did say that, yes?
I did.
So moving on, will the bailiff please screen share Exhibit 3?
Did you say Exhibit 2 or Exhibit?
Exhibit 3. So, Ms. Westfall, you've never seen this warning sign, yes?
No, I have not.
Scrolling to the second page. You've never seen this one either?
No, I haven't.
So to verify, you saw no warning signs posted throughout the zoo, even though you visited a week after Harper deemed the structure unsafe?
Well, that's just because I asked for the exhibit to be clear so that way I can see the fence in full detail. And I was really only focused on the baboon exhibit when I went that day because that is what I was called to inspect. I wasn't really paying attention to the rest of the zoo. So if their signs were up, I really wouldn't have noticed.
Even at the exhibit, there were no signs, correct?
No, because I asked for it to be cleared.
Moving on, after your inspection, you sent Jordan an invoice, yes?
I did, yes. Just as a formality, though. I didn't expect him to do anything with it.
Will the bailiff please screen share Exhibit 9, which has already been entered into evidence? So you've known that closing down the exhibit would be would financially ruin the zoo, yes?
That's what Jordan told me.
And you even indicated that a full replacement would be far from cheap, totaling over $7,600, correct?
Yes, but that includes lots of different aspects of the price. And if you compare it to the prices of other fences, it's actually a pretty good deal. At Vaughter and Westfall, we really pride ourselves on being able to find the highest quality materials for the lowest possible price.
So to clarify, if the zoo shut down, you would have lost a major client. Is that right?
Well, yes, but I have lots of other major clients. It really wouldn't have been that big of a deal.
The zoo was one of your first and most major contracts, yes?
It was one of my first contracts, but Vaughter and Westfall handles both residential and commercial cases all across Continental. We have lots of major contracts.
No further questions, Your Honor. I'd like to reserve the remainder of my time.
Thank you, counsel. Would there be a redirect of this witness?
Your Honor, before I make that decision, may I inquire as to how much time the defense has remaining for direct examinations?
You have 6 minutes and 59 seconds.
Yes, Your Honor, very briefly. Ms. Westfall, could you please explain to the jury your relationship with the Robinson Zoo?
I mean, it's purely professional. I've been working with the Robinson Zoo for 14 years, and we've done lots of jobs and repairs for them. But I have the same relationship with the Robinson Zoo that I have with other clients. It's not anything out of the ordinary.
And would you ever prioritize them over any of your other clients?
No, I wouldn't. Like I said, I have the same relationship with the Robinson Zoo that I have with most of my other clients. They all hold the same importance in my line of work.
Thank you, Ms. Westfall. Your Honor, I have no further questions.
Will there be a recross?
Yes, Your Honor, very briefly. Ms. Westfall, you would say that in the world of business, losing any client is extremely bad for business, correct?
Objection, Your Honor, out of the scope of my cross-examination.
Your Honor,
You may respond.
the counsel has opened the door to this line of questioning, seeing as he was establishing the relationship between Harper Reynolds and the zoo's working relationship, and therefore that is about business as is my line of questioning.
Your Honor, may I be heard?
Can you repeat your question, plaintiff, before the defense responds?
You would say that in the world of business, losing any major client is important, is bad for business, yeah.
Counsel, you may respond briefly.
Yes, Your Honor. My line of questioning was directly about the Robinson Zoo and only that relationship, no other relationship. Additionally, asking such a question is asking Ms. Westfall to give a hypothetical answer and asking her to speculate as to what would or what would not occur. Therefore, this is one outside of the scope of my cross-examination and is speculative to ask my witness.
I agree. Objection sustained.
Yes, Your Honor.
Sorry. So you would say that losing the zoo as a client is still really bad for business, yes?
I mean, it wouldn't be good for business, but we have lots of other clients and we would have been able to pull through just fine.
Thank you. No further questions, Your Honor.
Thank you, witness. You may step down. Is the defense prepared to call its last witness?
Yes, Your Honor. At this time, the defense calls Taylor Carpenter to the stand.
You have 5 minutes and 31 seconds remaining.
Before I begin, I'd just like to make sure that both Your Honor and opposing counsel can hear and see myself and my witness clearly. Please state your name for the court.
My name is Taylor Carpenter.
Where are you from?
I was born and raised in Rockville Continental, and I ended up attending Southeastern State University in 2016. The plan was to attend vet school, but it didn't seem right at the time, so I decided to come back.
What brought you back to Continental?
Well, sadly, my mom got sick, and I decided it would be best for me to leave school and come back and take care of her. Family's more important than anything, so I decided to stay here and find a job.
Where did you end up finding work?
I was fortunate enough to find a job teaching biology in my alma mater, McConnell High. Go Bucks.
How would you describe your teaching style?
I would say my style as a teacher is pretty laid back. All I ask for my students is to be engaged in my class, take some kind of notes, and stay off their phones. I figured that since these guys were seniors, that shouldn't be very difficult.
Did you ever have any problems in your classroom?
For the most part, I didn't have any problems, but this past year was different.
What was different about that year?
Well, it seemed to me that the students in McConnell High were glued to their phones more than ever, and apparently it was because of the rise of this new app called ClickClack.
Did you ever have any problems with ClickClack use in your classroom?
For the most part, my students did a good job of not making it a problem, but my only repeat offender was Tommy Thompson.
Who was Tommy Thompson?
Tommy Thompson was one of my students. Good kid, made good grades, just had a bad habit of being on his phone all the time. And with ClickClack, that's when it really was a problem.
How did you notice ClickClack to influence Tommy's behavior?
he was getting in a lot of trouble because of it. I remember specifically in October of that year, I was in the middle of my favorite lesson on speciation, and out of nowhere, Tommy yelled, "Do it for the click-clack," and jumped out of my window. That was the last straw for me. Not only did he disrupt my rules and disrupt my class, break my rules, but he could have gotten seriously hurt because of that.
Did he face any consequences for this?
Yes, I decided it would be best to give him a detention, and I warned him that if he did anything like that again, the consequences would be great.
Was Tommy able to stay out of trouble following this incident?
No, about a month later, I heard him devising another plan to film a click-clack.
What exactly did you hear Tommy say?
I heard him talking about filming a handstand challenge, and this was the day before our field trip. I was stunned, especially since I made my warning very clear on the consequences of filming another click-clack.
Now, how did you respond to hearing this?
I decided to go up to the entire class and address my no phone policy once again. I wanted to make it crystal clear that I didn't want to see a single phone at that field trip.
Now, on the day of the field trip, how did that begin?
Well, I woke up nervous that morning thinking that Tommy was going to devise a plan. Eventually, I got to the school at 9, took attendance, and we made it to the field trip around 10 o'clock. And that's when we met up with our tour guide, Avery Fields. I actually started to look forward to that day because this is a chance for me to connect with my students a little more. Sometimes seeing the biology in action can help them appreciate the class.
What happened next that day on the tour?
Well, that's when I was walking around and I saw the warning signs.
Bailiff, if you would screen share what has been pre-entered as Exhibit 3. And if I could share a copy of the exhibit with my witness.
You may.
What is this document?
These were the warning signs posted throughout the Robinson Zoo.
And was there anything on them that would stand out? If you could scroll down to the second page.
Yes, actually, specifically the no handstand rule. I figured that if I couldn't get through to Tommy about doing a handstand, the many signs posted all throughout the Robinson Zoo should do the trick.
Bailiff, thank you. You can stop screen sharing. And did you notice Tommy following all the rules that day at the zoo?
Yes, he and my other students appeared to be following the rules, and we had just made it to the end of the tour, which is the baboon exhibit. And that's when I decided to go to the bathroom. I told Avery to just keep an eye on them, but I figured that since my guys were seniors, and they're 18 years old, that they'd be able to handle themselves.
And what happened when you were on the way back from the bathroom?
Well, I was going back a few minutes after 11, and that's when I heard something from Lee Stevens. I didn't know what it was, but I knew I immediately had to start running.
And what was the statement that you heard?
I heard Lee Stevens say, "Hurry up, Tommy. We need to finish this before Carpenter gets back."
In accordance with Rule 801 of the Federal Rules of Evidence, this is hearsay, and therefore it is not admissible.
Your Honor, may I respond?
You may.
This statement is clearly not being used for the truth of the matter. Rather, it is being used for the subsequent action. Mr. Carpenter clearly stated that because he heard this statement, he began running towards the baboon exhibit. It is not being used for the truth of the matter. Rather, it is being used for that subsequent action that Mr. Carpenter took after hearing it.
Your Honor, may I respond?
You may.
In accordance with Crenshaw v. Roth 2001, hearsay is an out-of-court statement made by a witness, and this is exactly what this line of questioning is. It is going to the truth of the matter asserted. And with Rule 801, the line of questioning is calling for hearsay. My opposing counsel did not respond directly to the rule of 801. And this is an out-of-court statement for the truth of the matter asserted. That is precisely what this line of questioning is attempting to do.
Your Honor, may I respond?
You may.
The Rule 801 is only necessary for application if the statement is in fact hearsay. In this case, hearsay must be an out-of-court statement made for the truth of the matter asserted. This statement was not made for the truth of the matter asserted. Rather, it is being used to show the subsequent action on the listener, Mr. Carpenter. Mr. Carpenter began running after hearing this statement. That was the subsequent action he took, and that is why it is being presented in court today.
Counsel, do you have a final response?
Yes, Your Honor. Seeing that Rule 801 is directly in relation to out-of-court statements, I just have to disagree with my opposing counsel with the idea that this is not for the truth of the matter asserted. It is precisely trying to evoke testimony from the witness, which would testify to whether or not to the overall question at hand today. And therefore, it is still hearsay, and due to that, it's not admissible.
Council, I'm going to overrule for now, but if you feel as the opposing counsel is asking questions that goes against what they had just said right there, where they're not asking that question, rather for the truth of the matter asserted, but for the fact on lister, then please feel free to object again, but I'm going to overrule for now.
So would you like to continue?
Yes, that's when I heard Lee Stevens say, "Hurry up, Tommy, we need to finish this before Carpenter gets back." Like I said, I didn't know what this meant, but I knew I had to get there immediately.
And what did you see when you made it to the baboon exhibit?
Never in my 32 years on this earth had I seen something like that. I saw Tommy doing a handstand on the railing, and Lee a few feet back pointing his phone, and he appeared to be filming. I immediately yelled at Tommy to get down and about all the warning signs posted throughout the zoo. And I couldn't believe.
This witness once again is testifying to an out-of-court statement under Rule 801 of the Federal Rules of Evidence, and therefore it is not admissible.
Your Honor, may I respond?
You may.
Pursuant to Rule 803-2, this is an excited utterance by the witness, seeing as he had just seen his student, Tommy Thompson, doing a handstand on the railing, which was a dangerous situation. He began yelling and warning him about the signs he saw and about the dangerousness of his action he was taking. This has been clearly established that it was an excited utterance because of the circumstances of Taylor Carpenter's statement.
Your Honor, may I respond?
You may.
803-2, I believe, is what my opposing counsel just reflected on, and that is specifically the stress of an event such as, for example, a car accident. Witnessing a car accident would be where an excited utterance would necessarily be directly applicable. Seeing that there was no necessarily seeing a handstand is not the same as necessarily seeing an accident occur, which is exactly what 803-2 is in reference to. And I don't believe that the handstand reaches, the alleged handstand reaches that same level that necessarily an accident would.
Your Honor,
I'm sorry, counsel. I tend to agree. I don't believe that the excited utterance has been met here in this case, so I'm going to sustain the objection.
yes, Your Honor. So what did you see Tommy doing exactly?
Like I said, I saw Tommy doing a handstand on the railing, and I couldn't believe he would endanger himself like that. And that's when the beam moved.
What happened when the beam moved?
Once the beam moved, so did the rest of the fence, and that's when Tommy fell in. I just wish that Tommy would have not only listened to me, but the Robinson Zoo and following the rules. Tommy was a young man with so much potential, but he seemed to care more about being recognized than his own safety.
Has been bifurcated, and therefore the witness is discussing the damages being maintained, and specifically in reference to Tommy Thompson and those damages. Due to the fact that this trial has been bifurcated under Hintz v. Aby, we cannot necessarily reflect on the damages, specifically the liability, and I ask my opposing counsel to move on from this line of questioning.
Your Honor, may I respond?
You may.
Pursuant to Continental Code 8001A4, the liability that opposing counsel is referring to in this case refers to the damages, the damages that my opposing counsel is referring to is in reference to future capability to create revenue, make money, things like that. The damages in that situation refer specifically to monetary gain. Nothing in Mr. Carpenter's statement had anything to do with monetary gain that would have a bearing on the damages phase of this or of another trial. In this case, this specifically goes to liability because Mr. Carpenter's statements were about the actions of Tommy Thompson that led up to his own death on the day in question.
Your Honor, if I may respond briefly.
Yes, briefly.
Once again, with Hintz v. Aby in 2019, the court is bifurcated. We should only be focusing on the liability, and the extent of the damages should not be discussed. So when we're discussing Tommy's character, that is beyond the focus of the liability, and therefore it is not admissible, and we should move on from this line of questioning.
Your Honor, may I respond?
No, counsel. I tend to agree with the defense. I'm going to overrule this objection. Please continue.
Yes, Your Honor. If you would like to continue your statement.
Yes, like I said, Tommy only seemed to care about being recognized more than his own safety.
No further questions, Your Honor.
Thank you, counsel. Will there be a cross to this witness?
Yes, Your Honor.
You have 3 minutes and 43 seconds.
Thank you. How are you doing today?
Doing good.
All right, so let's start by discussing, you never really intended, or at least saw yourself becoming a teacher, correct?
No, that wasn't the original plan, but like I said, my mother got sick and family's more important than anything, so I decided to camp out here, and I'm happy to be a biology teacher now.
So plans change and you became a teacher, and you specifically mentioned in your testimony your student Tommy Thompson, and how Tommy pulled a stunt in class with Lee Stevens once, right?
Yes, he did, and in the middle of one of my favorite lessons.
And during that stunt, you reprimanded him and you sent him to the principal's office.
Yes, I decided to give him a detention, and I warned him that if he did anything like that again, the consequences would be great.
But can you remind me, did you give Lee Stevens, who was also involved, a detention slip?
No, I deemed jumping out of a window much, much more worse than actually filming it.
So after that incident, you and Tommy's behavior much improved, did it not?
Yes, it did, but just a short while after, I heard him devising a plan to film another click-clack.
And on November 20th, you were taking your biology class to the zoo, and Tommy was initially behaving quite well, wasn't he not?
Yes, he was, but like I said, I overheard him devising another plan to film another click-clack.
But you say that you only saw a few warning signs throughout the zoo?
I saw warning signs all throughout the zoo.
But you specifically mentioned that only a few of them, correct?
Yes, but they would have been hard to miss.
But remind me, what exactly did you witness? Exactly around 11 o'clock went to the restroom, correct?
Yes, I did, just for a few minutes.
And you looked at Avery Field and you told her that she should be watching your class?
Yes, but like I've been saying, these guys are 18, some of them have jobs. I consider them adults, so I figured that they could be able to handle themselves.
So, but you specifically mentioned to her that you wanted her to watch Tommy and Lee, right?
Yes, just to keep an eye out on them and my 38 other students as well.
But you did specifically mention to Avery, that's a yes to, you did mention to Avery that she should specifically watch Tommy and Lee.
Yes, I did.
And you then went to the restroom, and when you were coming back, you yelled at Avery because you see her running back from the zoo office, correct?
Yes, that was a spur of the moment decision, and honestly, I should have never gone to the bathroom. That was my fault.
But you did use the restroom, and you mentioned to Avery when you were yelling at her that she was responsible for watching your class and that it was her fault.
Yes, I still live with that regret each and every day that I left my students, and that was my responsibility. I had to go get therapy because of that, and I can barely live with myself after that decision.
But that was a yes to my question, that you did in fact yell at Avery because she was responsible for watching your class in your absence.
Yes, it was a spur of the moment thing.
Thank you. No further questions at this time, Your Honor. I'd like to reserve any remaining time.
Thank you, counsel. Will there be a redirect of this witness?
Your Honor, may I inquire as to how much time I have remaining?
You have 38 seconds.
Yes, Your Honor, briefly. Mr. Carpenter, who do you believe was responsible for the unfortunate actions of November 20th?
I mean, me, myself, and I, that was my fault. I should have never left my students there.
And who exactly was it that was performing the actions on that day?
I saw Tommy Thompson doing a handstand.
No further questions, Your Honor.
Thank you, counsel. Will there be a cross to this witness?
Yes, Your Honor. Very briefly, can I inquire to how much time is remaining?
Yes, you have 15 seconds.
Thank you. So I would just like to clarify, Mr. Carpenter, one last time. You left and went to use the restroom, and when you came back, you yelled at Avery.
Yes, and that was my fault for leaving my students there.
Thank you, counsel. Witness, you may step down. Does the defense have any more witnesses?
No, Your Honor, at this time the defense rests.
Thank you. Is the plaintiff prepared to give its closing statement?
Yes, Your Honor. May I proceed?
You may.
On November 20th, 2019, Tommy Thompson went to the Robinson Zoo for a school field trip. Tommy leaned against the baboon exhibit, assuming that it was safe, but the fence collapsed from underneath him and sent him tumbling 25 feet to his death. Tommy died from a baboon attack, and it was all because the Robinson Zoo failed to ensure the safety of their guests. Your Honor, ladies and gentlemen of the jury, today, only you possess the power to secure justice for Tommy Thompson's wrongful death. Because the facts are simple. To create a safe environment is equivalent to setting up a line of dominoes. It requires caution, precision, and a little bit of anticipation. One wrong move and the entire structure collapses, just like the Robinson Zoo's fence did. But the Robinson Zoo made multiple wrong moves. First, we've proved that the Robinson Zoo breached their duty of care. In accordance with Franklin v. Thrasher, one breaches their duty if the risk is foreseeable. And zoo manager Jordan Hastings perfectly understood the risks, but chose to ignore them. But under the precedent set by Wagner versus ABC Toys, businesses must warn customers of all known dangers, but the Robinson Zoo failed to do so. But we've also proved that because the Robinson Zoo breached their duty of care, a boy died tragically. Tommy was unaware of the dangers of the baboon exhibit, but by the time the structure collapsed, it was too late to warn him. Tommy will never experience the thrills of graduating, falling in love, or even growing old, all because the Robinson Zoo stripped him of his future. But the defense tries to distort the facts of the case by calling on 3 witnesses. First, we hear from Jordan Hastings, the zoo's hot-headed manager who prioritized profits over safety. Despite Harper's instructions to close down the exhibit, Mr. Hastings refused because he perfectly understood that closing down the exhibit would be too costly for the zoo, and no one wants to lose over $7,600. But then we hear from Bailey Westfall, the zoo's long-term inspector. Miss Westfall indicated that she would have never even made a trip to the zoo if she had known that Harper was the one who inspected it. But even worse, Miss Westfall knew that closing down the exhibit would cost her business their most important client. So naturally, she deemed the fence safe for public use. And finally, we heard from Taylor Carpenter. At the zoo, Mr. Carpenter entrusted the care of his class to tour guide Avery Fields. But by the time Mr. Carpenter returned, Avery, the zoo employee, was nowhere to be seen, and Tommy, his student, was dead. Today, we, the plaintiff, have reached 3 critical conclusions with our witnesses, Avery Fields, Harper Reynolds, and Lee Stevens. First, Avery Fields was undertrained and underqualified. She neglected to warn her tour group of the dangerous baboons. She left her group unattended and even deleted possible security footage. All signs of the zoo's vicarious liability and negligence. But second, Harper Reynolds deemed the fence structurally unsafe. She instructed Jordan Hastings to shut down the exhibit until her second inspection. But she never heard back from Jordan because Jordan knew of the dangers, but he chose to ignore them. And finally, Lee Stevens, the only eyewitness, testifies to how Tommy was following all of the rules, but the structure still collapsed from underneath him. But most importantly, Lee Stevens testifies to how there were no warning signs. Today, we, the plaintiff, have proved beyond a preponderance of doubt that the Robinson Zoo breached their duty of care. And because they did, an innocent boy died tragically. Tommy died in an instant, but it was not just one instance that killed him. One wrong move after another, the Robinson Zoo's dominoes fell. Because when they tried to set up their line of dominoes to create a safe environment, they failed. The first domino knocked over when Jordan Hastings neglected to follow Harper Reynolds' instructions, knocking down the following dominoes until finally, all of the dominoes fell with Tommy Thompson. Thank you, and I'd like to reserve the remainder of my time for a rebuttal.
That is your right. Has the defense prepared a closing argument?
Your Honor. Before I begin, I'd just like to ask if it would be all right if I held a timer in my hand.
Sure.
Yes, Your Honor. Recognition over reason. May it please the court. My name is Isabella Torres, and I, alongside my co-counsel, represented the Robinson Zoo, the defendant in today's case. We showed you the truth about what happened on November 20th. That Tommy Thompson chose to do a handstand on the fence of the baboon exhibit. He chose to value stardom over his own safety. Now, you've heard that the plaintiff has brought a charge of negligence against the Robinson Zoo. They claim that it was their lack of ordinary care that caused Tommy's death. Now, they had to prove by a preponderance of the evidence that the Robinson Zoo failed or breached its duty of care and directly and proximately caused Tommy's death. But members of the jury, they failed to do so. Let's talk about why. The plaintiff's first requirement was to show that the Robinson Zoo breached its duty of care to Tommy Thompson. But as we heard today, the zoo did everything in its power and everything required by the standard of premise liability set out by Wagner v. ABC Toys to keep its visitors safe. After an inspection by Harper Reynolds, who didn't even bother to acknowledge the elasticity of the redwood the fence was built out of, Jordan was told to put up safety signs, close the exhibit, and only reopen it after it was signed off by a licensed contractor. And Jordan did just that. But what else he did was go above and beyond that. Even after the fence was certified to be safe to reopen, he left up the warning signs, continued to rigorously train all of his tour guides, and held safety meetings for every employee of the zoo so that they understood the rules that were needed to share with the guests. The Robinson Zoo did everything in their power in order to ensure that the visitors were safe. And every reasonable visitor who followed those clear rules was able to remain just that. Now, the plaintiff's second requirement was to show that the Robinson Zoo proximately caused Tommy's death. And they attempted to say that it was a lack of safety on their part that caused Tommy's fall. But it was the only pattern of unsafe behavior we saw today was that of Tommy Thompson. Because as you heard in court, Tommy had a plan. Every Wednesday, film a click-clack even crazier than the last. And Wednesday, November 20th, was no exception. Treacherous Tommy was going to entertain his millions of followers. He was going to perform his craziest stunt yet. And when he did that, he put the plan into action. And when that plan was in action, that leads us to the plaintiff's third requirement, direct cause. Tommy Thompson had a plan to do a handstand on the deck of the baboon exhibit. And when he put it into action, it tragically caused his death. Eyewitness Taylor Carpenter told you that he watched Lee Stevens film his best friend's final stunt. Tommy Thompson was the only person responsible for that choice. And as you heard from Bailey Westfall, it was only that unreasonable action that could have caused the fence to fail. Now, the defense has tried to tell you that this case is like setting up dominoes and that the Robinson Zoo knocked them over. But in reality, the only person knocking down dominoes was Tommy Thompson himself. Tommy had a plan. He set up every domino on its way. He was going to film the handstand challenge, and he talked about it the day before in class. He talked about it on the deck of the baboon exhibit when Avery Fields heard him say he was going to do it as soon as no one was looking. There was nothing that the Robinson Zoo could have done to save Tommy from himself. That is how we, the defense, have proven our burden of contributory negligence. That Tommy Thompson chose to prioritize the entertainment of his 5.3 million followers over his own safety. This is what demands a verdict of liable. Not for the Robinson Zoo, but for Tommy Thompson, who directly and proximately caused his own death, because he put recognition over reason. Thank you.
Thank you, counsel. Will there be a rebuttal?
Yeah.
You have 46 seconds.
This case is not about recognition over reason. It's about profits over safety. Jordan Hastings chose to save $7,600 over saving a life. No warning signs, no instructions, no training. Tommy Thompson did not plan to film a click-clack at the Robinson Zoo, but Tommy did not plan to die either. It was the Robinson Zoo that made the choice for him, and that's precisely why we in court today must find the Robinson Zoo guilty, not negligible, for negligence. Thank you, and
Thank you, counsel. And with that, court is now adjourned. A final verdict will be given soon. Just want to thank y'all.
Jake and Bella. Can y'all hear me okay? Sorry, I'm an echo. Jake and Bella, I need y'all to go do your score sheets now.
Okay.
The other round started 5 minutes before y'all, and they've been done for 40 minutes. So we've got to go. Yeah. So y'all go ahead and log off into your score sheets. Get those to y'all as soon as possible. Honestly, the other round's probably going to have to start in about 25 minutes just because our judges can only go so late into the afternoon. We have some other people coming on the next call other than our student judges. So we originally planned to give y'all like 40 minutes. I know we started a little behind, but we did not anticipate the trial to go this long. But great job, y'all. Y'all were both great. And just so y'all know, because the other team already knows, whoever makes it through this round will be going against Team 201 Spain Park. They were the highest scoring team coming out of the state competition, so they will get to choose the side they want to compete. So when they choose, they're supposed to let me know in a couple minutes. Then I will forward it on to whoever wins, and I'll let y'all know as soon as they get their ballots in who's advancing out of this round. Okay?
Thank you.
Yep. Okay. I'll let y'all know as soon as I can, but I have to go do some other tech stuff, so I'm going to go ahead and end this call. Feel free to send either me or Pierce an email if y'all have any questions at all. Okay? Great job, y'all.
Virtual handshake. Good to see y'all again.
Good job.
Good job.
Should we turn off our?
Hey guys, this is Pierce Godwin with the YMCA. Did y'all have a question? I saw y'all's hands up.
I know we were
trying to do a virtual handshake with the other team. Sorry about that.
Oh, no, you're good.